Research case study by Omar Koss. New York Times versus Sullivan. In this case, the New York Times is the petitioner asking the Supreme Court of the United States to overturn a ruling by the Alabama Supreme Court, which upheld a judgment awarding the respondent, L.B. Sullivan, one of three elected commissioners of the city of Montgomery, Alabama, whose duties included supervising the police department, damages in a civil libel action stemming from a full-page advertisement in the New York Times entitled Heed the Rising Voices. The third and sixth paragraphs of the 10-paragraph advertisement read as follow. In Montgomery, Alabama, after students sang My Country 'Tis of Thee on the state capitol steps, their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to the state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. The sixth paragraph reads, Again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home and almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. Sullivan alleges that when the ad references the police and arrests, they are referencing him personally, since he is the supervisor of the police department. According to Nolo.com, a statement is defamatory if it tends to hold the plaintiff, the subject of the statement, who is bringing the lawsuit, up to scorn, hatred, ridicule, disgrace, or contempt in the mind of any considerable and respectable segment of the community. There are certain types of statements that are automatically considered defamatory in some states. These types of statements are called defamatory per se. Statements that are defamatory per se include statements that claim that the plaintiff has committed a serious, notorious, or immoral crime, has an infectious, terrible disease, or is incompetent in his job or profession. Furthermore, since Sullivan is a public figure, the New York Times can only be held liable for defamation if it knew that the statement was false or if it acted with reckless disregard as to the truth or falsity of the statement. The court ruled that by not requiring the respondent to prove that the speech in question was motivated by actual malice, Alabama's libel law unconstitutionally infringed on the First Amendment's freedom of speech and freedom of press protections. The court ruled that the First Amendment of the United States Constitution protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice. Specifically, the rule of law applied by the Alabama courts was constitutionally deficient for failure to provide the petitioner the safeguards for freedom of speech and of the press that were guaranteed by the First and 14th Amendments of the Constitution in a libel action brought by a public official against critics of his official conduct. The original ruling was overturned. Gertz versus Welch. The petitioner in this case is Elmer Gertz, an attorney that was hired by the Nelson family to represent them in civil litigation against a Chicago police named Nuccio, who shot and killed a young member of their family in 1968. The respondent is Robert Welch, the publisher of American Opinion, a monthly outlet for the views of the John Birch Society. The court established that Elmer Gertz is a private person. The alleged defamatory statements about Gertz in the American Opinion article accuse Gertz of being the architect of a frame-up, a Leninist, and a communist fronter, and implied that petitioner had a criminal record. The managing editor of American Opinion made no effort to verify or substantiate the charges against petitioner. Instead, he appended an editorial introduction stating that the author had conducted extensive research into the Richard Nuccio case. Accusing an attorney of being the architect of a frame-up, a Leninist, and a communist fronter could severely affect said attorney's credibility, especially in the 70s, when anti-communist sentiment was front and center in America. These allegations could have forever tainted Gertz's reputation and affected his livelihood as a reputable attorney. To avoid this lawsuit, I would have corroborated the accuracy of the accusations made against Gertz, and I would have refrained from directly naming Gertz and consulted my own attorney to determine the liability behind the case in the article. Under Florida law, the elements of a defamation claim are that the defendant published a false statement about the plaintiff to a third party, and the falsity of the statement caused injury to the plaintiff. A plaintiff must also prove that the defendant's fault in publishing the statement amounted to at least negligence. The Florida Supreme Court ruled that the state no longer recognizes presumed damages for defamation per se in lawsuits against media defendants. Florida has a broad conception of public officials, a category of government actors who must prove actual malice in order to prevail on a defamation claim. Unlike most states, Florida still recognizes criminal libel. In Florida, a private figure bringing a defamation lawsuit generally must prove that the defendant was at least negligent with respect to the truth or falsity of the alleged defamation statements. Public officials, all-purpose public figures, and limited-purpose public figures must prove that the defendant acted with actual malice, i.e., knowing that the statements were false or recklessly disregarding their falsity. Florida's statute of limitations for defamation is 2 years. What I have learned from the Sullivan and Gertz cases can be applied to my future work in the communications industry by giving me a general awareness of the many different elements of a defamation lawsuit. Understanding the protection that Sullivan establishes for the media and the limitations that Gertz impose on that protection will be great assistance in how I draft a story, especially a story of public relevance and high profile. Thank you for listening.